You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that. Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull.
Is that really what's going on here? We don't have a great record. I'm left with the impression that two different concepts, ineffectiveness and insubordination, are being conflated here, that these lawyers were flouting her gag rule and that they were insubordinate. Where's the evidence in the record that they are constitutionally ineffective, that we're trying to protect the defendant from his own lawyers? It's hard to look at this record and not get the impression that the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, as in Wheat...
That's structural error. It is. Okay, you can shake your head, but how do we get this case back on? Well, you gave a press release. Well, the gag order was after the press release. Well, we don't like, what you filed with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. There's a new motion to transfer Mr. Allen filed by his current attorneys. You've got a constitutional right to counsel. He's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, that constitutional right is highly limited.
A judge has a very limited right to tell someone who their attorney can be.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, what Wheat says in weighing those competing rights, Wheat says in a highly deferential standard.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing, and I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice.
Claims of constitutional violation are extremely normal. They are extremely rare. Under the United States Supreme Court's jurisprudence in Wheat,
but it has to be done, there's a way that you do it, and it does not appear this was done the proper way. Back in chambers saying, you're either out or I'm going to publicly out you.
Counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing, and that was their choice.
Having read the transcript, was it a full and free choice?
These are very experienced lawyers. These are highly competent lawyers. These are very experienced lawyers. These are highly competent lawyers.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So,
well, we won't know what would have happened at a hearing that never happened, but you're right. I certainly acknowledge that there's a... She probably wouldn't have changed her mind.
What can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Under Wheat, there doesn't have to be a finding that they were actually ineffective, and this is under Wheat. We already have a polluted jury pool because of the inordinate pre-trial publicity that this case has garnered. Under Wheat, and I quote, intuition and judgment based upon experience. If counsel is capable in the pretrial stages of making this many mistakes.
He wants these attorneys. We're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. I'm really struggling with why he can't make that decision that's in his best interest and get this case moving again.
First, again, in Wheat.
I don't see Wheat as tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Wheat himself claimed...
Where are we on this?
...to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side, I think is your position.
Well, and even Wheat said the trial court, in exercising its discretion, is allowed to consider the totality of circumstances. Wheat went out of its way to say this decision can be based upon intuition and judgment.
How should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. That counsel in this case had engaged in conduct that was detrimental to his interests, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest, having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense.